In this episode, we talk about the Supreme Court's controversial order on stray dogs in Delhi NCR. We also talk about a Pakistani woman who allegedly entered India nearly 7 decades ago and has been identified amid the ongoing special intensive revision in Bihar. But we begin today with the concerns around a new bill that the opposition says could be used to selectively target leaders and destabilize state governments. Hi, I am Niharika Nanda and you are listening to Three Things, the Indian Express news show. Last Wednesday, Union Home Minister Amit Shah tabled the 130th Constitutional Amendment Bill in the Lok Sabha, sparking uproar and heated exchanges in the lower house. The bill seeks to remove a central or a state minister who is facing allegations of corruption or serious offences and has been detained for at least 30 days.
This bill opens the door for political misuse by instrumentalities of the state whose arbitrary conduct has been repeatedly frowned upon by the Supreme Court. And finally, it throws all existing constitutional safeguards to the winds.
This bill is to target the opposition ruling government. This bill is to threaten the people like Nitish Kumar and Chandrababu Naidu.
The bill, as you heard, has drawn sharp objections from the opposition leaders who argue that it allows ministers to lose their posts merely on the basis of an arrest rather than a conviction. Now, shortly after being introduced, the bill was referred to a joint parliamentary committee, which is expected to present its report before the first day of the next parliament session. To understand the concerns surrounding this bill and what it could mean for state governments, my colleague Shashank Bhargav speaks to the Indian Express's national legal editor, Apurva Vishwanath.
Apurva, before we talk about the concerns and what we understand might have been the impetus for this bill, could you talk about what the government is saying its stated objective is?
So, this is a constitutional amendment bill. So there are certain provisions in the constitution which deal with the formation of the union cabinet, the state cabinet, and the cabinets in the union territories, right? So these are the provisions that the government is looking to amend. So every bill essentially has something called the statement of objects and reason, where the government explains why this bill is being brought about. So for this, the 130th Constitution Amendment Bill, it says that, if a minister has been arrested and is in the custody, that puts a question on their constitutional morality, their right to govern people. And because people have reposed their faith in somebody who is not, a person who's in police custody or has been detained. So that's why during the period of that custody, they will have to be removed from being a minister. Of course, this doesn't mean that they can never be a minister. So once you get released from jail, the bill says that you can go back to being a minister if the legislators elect you again. That includes the prime minister, all the union ministers, chief ministers, and also ministers in union territories and states.
And what is the trigger for this bill? Why is the government bringing this out now?
Look, this concern about criminalization of politics has been there, for as long as India has existed. It's a series of legislations, court interventions have kind of brought in more transparency in electoral politics to ensure that those who govern us are not all crooks or not all charged with serious offences. In fact, the first such law came in 1951 itself in the Representation of People's Act. That is the primary bill that governs all our elections and, how we elect our leaders essentially. So that bill has a disqualification law which says that, if you've been convicted of an offence which is punishable by a sentence of at least 2 years, right, then you will be disqualified from contesting any future elections. If you remember, just recently, this is a couple of years ago, Rahul Gandhi was convicted in a case of defamation. And the Supreme Court stayed the conviction, of course. But had the court not done that, he could not have contested elections as a member of parliament from Kerala. Right. So there is that law and it came, way back in 1951. So it means that even as this republic was born, there was this concern that we should not have tainted legislators. Right. That has, of course, been built upon over the years. Now what you have is an emphasis on the citizens' right to vote, which means, bring in more transparency, tell them before they elect who they are voting for, right? So there is a declaration that is made on the number of criminal cases of a person contesting an election and all of these details. So over the years, these have come from Supreme Court directives essentially. But what this law does, or how this is different, the current constitutional bill, is that, it looks at pushing this yardstick. What we have right now is removal after conviction. But now this bill says they will be removed if they spend just 30 consecutive days in custody. And that throws up a whole lot of questions on its legality.
Right. The obvious question is that should a minister be removed from their post without having been convicted? Innocent until proven guilty. And this especially considering that in India, we've seen so many opposition leaders being accused in cases related to the ED, for example. This is what happened to Kejriwal. Rahul Gandhi's defamation case, of course, you mentioned. So that is one question, whether they should be removed from their post without having been convicted. And the second point is whether they should be removed just after 30 days.
So there is also this long-standing concern about whether conviction as a yardstick is actually working well. Because, as we know, our trials take far too long. Criminal convictions come after decades. And it's usually when the politician is out of power and he's in the opposition that the trial actually takes place. If you look at the disproportionate assets case against Jayalalitha, in fact, the verdict from the Supreme Court eventually came after her death, right? So, these are very legitimate concerns that way, because our justice system is so clogged, many of these things never see the day of light, right? So you have very few politicians who actually are disbarred from contesting elections. If you look at, the law, how it's evolved since 1951, it's usually when they're out of power or when there is an opposition party which has decided that they will be put behind bars, and that's when convictions happen in India. But to address this issue, the government is saying, let's shift the timeline and say that we do it at the time of arrest. In fact, there's been a debate in the Law Commission and the Supreme Court also about this. And even the Law Commission had recommended way back in 2004, and then the EC also said the same thing in 2014, that the prima facie guilt has to come after some judicial application of mind, which means a judge or a neutral party must at the least have a preliminary sense that someone is guilty of an offense. And in our legal system, that comes when, say, charges are framed against a person in court.
And how long does that take? Because here we are talking about this 30-day window, right? So how short is that?
See, 30 days is a speck, really, because the police gets about 90 days to file a charge sheet. And also, if you look at the opposition leaders who were sort of taken into custody before the elections last year, they all come under very stringent special legislations. These special legislations anyway make bail very difficult, anyway have a very high standard of proof and say that, the onus is on the person to prove that he is innocent.
In a PMLA case, for example.
Yeah, the PMLA, for example, which was the primary legislation used against, say, Hemant Soren, Arvind Kejriwal, many other leaders of the Aam Aadmi Party, ministers, Satyendra Jain, Manish Sisodia. So 30 days is too small a window because a court will grant the police remand for 15 days. In most cases. But having said that, the question really is, because the bill says once they are back from custody, right? That means, let's say after 30 days, they do get bail. They come back and they can still be a minister again. So it's not as if that questionable character has disappeared because they're out of prison, right? The case still exists on them. The same conditions exist, just that they are not in prison. So one way to look at it is the government is just trying to address the issue that a minister cannot function or work for the government from prison. So if he's in prison, then he can't be a minister for that period. But apart from that, this bill does nothing else.
And on the face of it, and a lot of people might be thinking this, that isn't that a good thing? Why should someone who is in jail be allowed to work for the government?
Yeah, on the face of it, it might seem like a good thing. But this is obviously happening in a context. And the context is that it gives central agencies a very, very easy way to destabilize a state government, for example. Because central agencies can arrest a minister, and that means, the minister can't function. say if they've picked up a chief minister, like it happened in the case of Hemant Soren and Kejriwal, that effectively destabilizes the political structure in that party and the state, right? So, I mean, this is not a desirable situation, nor this is something that our existing legal framework has. And I say this because, when it comes to arresting a legislator or a minister, right, a public servant, in fact, we have a higher bar. We ask for sanction. We ask for permission from the governor and other people just to ensure that they are not unfairly arrested. And especially this comes at a time when even the Supreme Court has legitimately raised questions on the conduct of ED, right? In the case of political leaders who have been arrested. While granting bail to Manish Sisodia, the Supreme Court did say that the ED's vast powers must be checked again. They must be reined in. The manner in which the ED made these arrests came under the scanner in the Supreme Court. So now to, sort of legitimize that with a legislation like this, that is the problematic part.
And so does this bill also then give the centre a lot more power and give central agencies a lot more power over state governments, shifting that balance a lot more?
Yeah, absolutely. Whoever controls these central agencies and these idioms of CBI being a caged parrot or the ED being used selectively against opposition leaders, none of this is new conversation. In fact, this is something that the Supreme Court has said in as many words. And if you look at the recent discharge of Satyendra Jain, one of the first cases hoisted against him has completely fallen apart in court. But while their government was in power in Delhi, this minister was in jail, right? And for a considerable amount of period of time. So to think that somebody being taken into custody is proof of their moral turpitude, that is the problematic part in this constitutional amendment bill that has been proposed.
And do we assess that this bill will likely be challenged in the courts then?
I mean, the bill has just been sent to a joint committee. It's been tabled and sent to a joint committee. There are, I think, a lot more hurdles or hoops to pass before we look at a constitutional challenge in court. First is whether the bill gets passed. The joint committee will include people from the opposition as well. So the comments that come from there and whether the bill is modified subsequently. And then when it is being passed, you need a majority of 2/3 in voting in the House. So allies have to support the bill. I mean, it will be tested because it's not just the party that is in power, right? Tomorrow, this party can be out of power and some other party can be in power. So how the chances of this bill getting weaponized is something that even the parliamentarians will have to discuss and debate in the parliament. And subsequently, if the bill gets passed, then of course there could be a challenge in the Supreme Court again.
And does it also raise concerns for voters and the larger democratic process? Because these leaders, after all, are elected by the people and they are the ones who will be removed from their positions.
I mean, there are both ways to look at it. One way, the centre could argue that they are mediating between this will of the people and trying to ensure that their will is not reposed in a person who is accused of a crime. That is the argument that the bill makes, that if I have voted for a person, I have a reasonable expectation that this person will not end up in jail, right? But the other argument is also that, when a voter has put their trust in a particular legislator, till a court says that someone is guilty of an offense, should the government, should the central agency sort of mediate and say that, but this is not the person who you should have put in your trust in. A court doing that is a different thing because the court is a neutral arbiter of truth in this country. But the agency deciding this raises questions again.
And next, we turn to the Supreme Court's recent controversial order regarding Delhi's stray dogs. On 11th of August, a 2-judge bench of Justices J.B. Pardiwala and R. Madhavan directed that all stray dogs in Delhi NCR be permanently moved to shelter homes with no possibility of release. Now, this order sparked widespread outrage and opposition from animal welfare groups and dog lovers. Now, after this, the court referred the case to a larger 3-judge bench, which on Friday issued a fresh order. To understand what this new order says and how it differs from the earlier one, we are joined by the Indian Express's Vineet Bhalla. So, Vineet, for those of who might not know what all the August 11 order directed, could you talk about exactly what it had said?
So on July 28th, the bench of Justices Pardiwala and Mahadevan had started a suo moto case in this regard. What that means is that on its own accord, this bench looked into the matter of stray dogs in Delhi on the basis of a news report in Times of India that had been published earlier that morning about some 6-year-old girl dying due to rabies after getting bitten by a stray dog. And in that case, on August 11th, the bench of Justices Pardiwala and Mahadevan had given this order stating that all stray dogs in Delhi, Gurgaon, Ghaziabad, Noida and Faridabad, they will have to be picked up by municipal authorities and kept in shelters or pounds that the municipalities will have to create. And these dogs, once detained, they cannot be let out back into the streets. The bench also ordered that any person who interferes in the implementation of this order would be proceeded with under the contempt of powers of the Supreme Court. Yeah, I think those were the main directions of the court in this regard.
And what kind of a reaction would you say this order received?
There was massive outrage, not just in Delhi NCR, but also other parts of the country against this order. There were several people who were protesting against this. In the city of Delhi, there were several more people who were registering their dissent on social media. This really turned into a very emotive issue that polarized people because I think the society became quickly divided into two camps, right? The pro-stray dog camp and the anti-stray dog camp. And there was a lot of discourse between these two groups as to what is the best solution to manage stray dogs in NCR. We also saw, curiously enough, some other high courts in the country gave out similar orders for their respective cities. So on August 11th, when the Supreme Court came out with this order, the Rajasthan High Court also came out with a very similar order asking for stray dogs to be removed from the city of Jaipur. Few days after that, we had the Madras High Court discuss whether it is feasible to implement something similar in the city of Chennai. So this created a lot of, I think, very loud, not just outrage, but also some very polarizing discourse among people.
And while speaking out against this order, what were the organizations and the people demanding?
I think the main demands of these pro-animal activists and advocates were that stray dog management be carried out as per the existing policy that we had in India, which was prescribed in the Animal Birth Control Rules of 2023. Now, what the Animal Birth Control Rules, the ABC rules prescribe is a capture, sterilize and release policy, as per which stray dogs are to be captured by municipal corporations only for sterilization and immunization, post which they are to be rehabilitated back into the areas they were picked up from. So the ABC rules envisage all stray dogs and other domestic animals for that matter as community animals. And under the ABC rules, you cannot relocate community animals from where they live. So this was the main demand of the stray dog advocates, that we don't do anything with the stray dogs that goes against the ABC rules.
Okay, so following the outrage, we understand that the Supreme Court appointed a larger bench of 3 judges to look into the matter.
Yeah. So, as we discussed, there was a lot of outrage after this August 11th order, right? And several advocates, they kept mentioning before the Chief Justice of India, Justice B.R. Gavai, that this order needs to be reconsidered. There were also campaigns among stray dog activists and advocates about writing emails and letters to the Chief Justice of India to reconsider this matter. So what Chief Justice B.R. Gavai did was he constituted a 3-judge bench comprising Justices Vikram Nath, Sandeep Mehta and N.V. Anjaria. to hear this matter afresh. The reason why he did this was because a lot of lawyers had mentioned before him how this order by Justices Pardiwala and Mahadevan went against earlier orders of the Supreme Court by benches of 2-judge strength. So when there are conflicting orders by similar strength benches of any court, the Chief Justice of that court places the matter before a larger bench to resolve that conflict. And this is what Chief Justice Gavai did here. He placed the matter before the bench of Justices Nath, Mehta and Anjaria. This bench heard the matter on last Friday and had reserved its interim order, which was then pronounced on August 22. And one of the reasons that the larger bench, the 3-judge bench, gave on Friday in its order to stay to modify the 2-judge bench's order is because words that they used were that the order seems to be too harsh and maybe impossible to comply with.
So, Vineet, what does the order given by the new bench say and how different it is from the earlier one?
So, what the new bench ordered in this on Friday is that it stayed parts of the August 11th order. The main portion of the August 11th order that it stayed was the direction that dogs, when they are stray dogs after being picked up, they cannot be released back on the streets. So this portion of the order was stayed, which means that the new bench said that after these dogs are picked up and they are sterilized and immunized, they will have to be rehabilitated back to the areas where they were picked up from. This is in compliance with the ABC rules. However, the court mentioned in its directions that dogs which have rabies or dogs who display aggressive behavior, once they are picked up by municipal authorities and sterilized and immunized, they will not be released back into the streets. So the larger 3-judge bench, it did not interfere with the August 11 order regarding creation of dog shelters and pounds. However, it said that these dog shelters and pounds will only be used to keep dogs that are infected with rabies and that display aggressive behavior. Another new direction that the 3-judge bench came up with is that it said that municipal authorities shall create dedicated feeding spaces for stray dogs in each municipal ward. And people who feed dogs will only be allowed to feed dogs at these designated feeding spaces and nowhere else. This is also something that we already see in the ABC rules. The ABC rules mention that feeding spots shall be designated by RWAs in consultation with dog feeders. What this order did is that it said it delegated this responsibility to municipal authorities instead.
And Vineet, we understand that this order also had directives for the petitioners in this matter. So what did the order say about that?
So another interesting thing that this new larger bench did was that it made this requirement that each individual dog lover and each NGO that had approached the Supreme Court as an intervener in this matter, individuals were asked to deposit rupees 25,000 and NGOs were asked to deposit 2 lakh rupees with the Supreme Court registry within 7 days. And if they don't do this, then they will not be allowed to appear in this matter any further. And the court mandated that this amount deposited would be utilized for the creation of infrastructure for stray dogs. I think the court did this to give the message to people who were intervening in this matter to put their money where their mouth is. And another important thing that the larger bench did is that it expanded the scope of this case from NCR to the whole of India. So while this order that the court gave on Friday, it's restricted only to Delhi and the NCR cities, any future proceedings in this case will have pan-India implications. So it'll be interesting how this bench and the court proceeds in this case, because that will have implications not just for NCR but for the whole of India.
And Vineet, some things, like you mentioned, have not been changed, like rabid dogs would still be kept in shelters and pounds. So what are some of the provisions from the previous order that have been kept intact?
Yeah, so the court did say that the larger bench said that the 2-judge bench's order direction to create dog shelters and dog pounds, that will continue. The 2-judge benches order that people who interfere in the work of municipal authorities with regard to stray dog management, they will be proceeded with under the law. That shall continue. And the 2-judge bench had also come out with some other directions regarding the creation of rabies helpline, and all medical facilities will have to put out in the public domain the availability of rabies vaccines at those facilities. So those directions will continue. The municipal authorities were also ordered by the 2-judge bench to record the number of dogs that they pick up and then they sterilize and immunize. So this order was also not interfered by the 3-judge bench. So these records will of all the dogs that are captured, sterilized, dewormed, immunized, and then relocated, those numbers will have to be recorded by municipal authorities.
And in the end, we talk about a Pakistani woman who allegedly entered India nearly 7 decades ago and has been identified on the draft electoral roll in Bihar's Bhagalpur amid the ongoing special intensive revision, prompting an official inquiry and steps for her removal from the voter list. The Indian Express's Himanshu Harsh reported that the development emerged following a verification drive initiated by the Ministry of Home Affairs to identify foreign nationals residing in India beyond the validity of their visas. Officials said that the name of the woman not only appeared in the state's voter list but had also been verified during the SIR process. Harsh wrote that the booth-level officer or the BLO concerned said, quote, I received a letter from the department containing her passport and visa details, which confirmed her Pakistani nationality. Her passport was issued in Rangpur in 1956 and her associated visa dates back to 1958. Unquote. The BLO added that based on the instructions, she checked the information and found her name in the draft roll. The woman was in poor health and could not engage in conversation. As per the orders, the BLO completed the formalities and the process to delete her name from the voter roll was initiated. District Magistrate of Bhagalpur, Dr. Naval Kishore Chaudhary, confirmed the action and said that a formal investigation is in progress. According to Harsh, further investigation into the circumstances of her continued residence in India and her inclusion in the voter list will be conducted by the relevant departments. The special intensive revision of the voter list in Bihar was launched in July ahead of the upcoming assembly polls, with enumeration forms being distributed and gathered back in the first phase during 25th of June to 25th of July. The eligible voters were then given a month to submit supporting documents for their enumeration forms while allowing objections and claims during the period. Yesterday, the ECI communicated that it had received documents from 98.2% of the listed electors in Bihar's draft rolls. You were listening to 3 Things by the Indian Express. Today's show was edited and mixed by Suresh Pawar and produced by Shashank Bhargav and me, Niharika Nanda. If you like the show, then do subscribe to us wherever you get your podcasts. You can also recommend the show to someone you think will like it. Share it with a friend or someone in your family. It's the best way for people to get to know about us. You can also tweet us at Express Audio and write to us at podcasts@indianexpress.com.